Very good. Okay, I'm live. I think 6 more pages in this reading. So these will be short cases. 2 of them. Starting with Brendlin versus California, 2007. Justice Souter delivered the opinion of the court. Following a traffic stop conceded to be illegal for lack of reasonable suspicion, passenger Brendlin was found to have an outstanding arrest warrant. He was arrested, and drugs and drug paraphernalia were found on his person and in the car in searches incident to his arrest. Brendlin's claim that evidence was the fruit of an illegal seizure by stopping the car was rejected by the California Supreme Court on the grounds that Brendlin, as a mere passenger, had not been seized by virtue of the vehicle being stopped. A person is seized by the police and thus entitled to challenge the government's action under the Fourth Amendment when the officer, by means of physical force or show of authority, terminates or restrains his freedom of movement. Citing Florida v. Bostick, 1981, through means intentionally applied. Citing Brower v. County of Inyo, 1989. Thus, the unintended person may be the object of the detention, so long as the detention is willful and not merely the consequence of an unknowing act. The police officer may make a seizure by the show of authority and without the use of physical force, but there is no seizure without actual submission. Otherwise, there is at most an attempted seizure so far as the Fourth Amendment is concerned. When the actions of the police do not show an unambiguous intent to restrain, or when an individual's submission of a show of governmental authority takes the form of passive acquiescence, there needs to be some test for telling when a seizure occurs in response to authority and when it does not. The test was devised by Justice Stewart in U.S. v. Mendenhall, that a seizure occurs if, in view of all the circumstances surrounding the incident, a reasonable person would have believed that he was not free to leave. From Mendenhall, which is common law. Test for seizure. Next page. Are there footnotes? No footnotes on this page. A lot of footnotes. Talking about Arizona versus Johnson on the next page. Stop in a vehicle. License plate check. Reveal the registration suspended. Civil. And somebody attending the backseat passenger who had no identification admitting to serving time for burglary, get out, and searches wet waste. And what did the unanimous Supreme Court reversed what? They reversed. Okay. The state court didn't believe there was reason. The Supreme Court reversed, knowing the Terry prerequisites for Frisk were a lawful stop. They're present because, so the search was reasonable, in other words. Looking at Terry. Where was I? Okay, the top of this page. Are there any others? They're citing Brendlin. Okay, but that is the case we're in. Am I wrong? Yeah. Okay, so second page of the Brendlin majority opinion, in the middle of the sentence, and start at the beginning. ... added that when a person has no desire to leave for reasons unrelated to the police presence, the coercive effect of the encounter can be measured better by asking whether a reasonable person would feel free to decline the officer's request or otherwise terminate the encounter. Bostick Supra. The law is settled that in Fourth Amendment terms, a traffic stop entails a seizure of the driver, even though the purpose of the stop is limited and the resulting detention quite brief. And although we have not until today squarely answered the question whether a passenger is also seized, We have said over and over in dicta that during a traffic stop, an officer seizes everyone in the vehicle, not just the driver. The state concedes that the police had no adequate justification to pull the car over, but argues that the passenger was not seized and thus cannot claim that the evidence was tainted by an unconstitutional stop. We resolve this question by asking whether the reasonable person in Brendlin's position, when the car stopped, would have believed himself free to terminate the encounter between the police and himself. We think that in these circumstances, any reasonable passenger would have understood the police officers to be exercising control to the point that no one in the car was free to depart without police permission. Right? Any traffic stop necessarily curtails the travel of passenger, has chosen just as much as it halts the driver, diverting from both from the stream of traffic to the side of the road, and the police activity that normally amounts to intrusion on privacy and personal security does not normally and did not here distinguish between passenger and driver. An officer who orders one particular car to pull over acts with an implicit claim of right based on fault of some sort, and a sensible person would not expect a police officer to allow people to come and go freely from the physical focal point of the investigation into faulty behavior or wrongdoing. If the likely wrongdoing is not the driving, the passenger will reasonably feel subject to suspicion owing a close association, but even when the wrongdoing is only bad driving, the passenger will expect to be subject to some scrutiny, and his attempt to leave the scene would be so obviously likely to prompt an objection from the officer that no passenger would feel free to leave in the first place. It is also reasonable for passengers to expect that the police officer at the scene of a crime, arrest, or investigation will not let people move around in ways that could jeopardize his safety. In Maryland v. Wilson, 1987, we held that during a lawful traffic stop, an officer may order a passenger out of the car as a precautionary measure without reasonable suspicion that the passenger poses a safety risk. In fashioning this rule, we invoked our earlier statement that the risk of harm to both the police and the occupants is minimized if the officers routinely exercise unquestioned command in the situation. What we have said in these opinions probably reflects a societal expectation of unquestioned police command at odds with any notion that a passenger would feel free to leave or to terminate the personal encounter in any way without advance permission. Our conclusion comports with the views of all 9 federal courts of appeals in nearly every state court to have ruled on the question, and the treaty's writers share this prevailing judicial view that a passenger may bring a Fourth Amendment challenge to the legality of a traffic stop. The contrary conclusion drawn by the Supreme Court of California that seizure came only with formal arrest reflects 3 premises as to which we respectfully disagree. First, the state Supreme Court reasoned that Brendlin was not seized by the stop because Deputy Sheriff Brokenbaugh only intended to investigate driver Simmeroth and did not direct a show of authority towards Brendlin. The court saw Brokenbaugh's flashing lights as directed at the driver and pointed to the lack of record evidence that Brokenbaugh was even aware Brendlin was in the car prior to the vehicle stop. But that view of the facts ignores the objective Mendenhall test that a reasonable passenger would understand. To the extent that there is anything ambiguous in the show of force, was it fairly seen as directed only at the driver or at the car and its occupants? The test resolves the ambiguity here. It leads to the intuitive conclusion that all the occupants were subject to like control by the successful display of authority. California defends the state Supreme Court's ruling on this point by citing our cases holding that seizure requires a purposeful, deliberate act of detention. But the intent that counts under the Fourth Amendment is the intent that has been conveyed to the person confronted, and the criterion of willful restriction on freedom of movement is no invitation to look to subjective intent when determining who is seized. The issue is whether a reasonable passenger would have perceived that the show of authority was at least partly directed at him and that he was thus not free to ignore the police presence and go about his business. Second, the Supreme Court of California assumed that Brendlin, as the passenger, had no ability to submit to the deputy's show of authority because only the driver was in control of the moving vehicle, but what may amount to submission depends on what a person was doing before the show of authority. A fleeing man is not seized until he is physically overpowered, but when sitting in chair may submit to authority by not getting up to run away. Here, Brendlin had no effective way to signal submission while the car was still moving on the roadway, but once it came to a stop, he could, and apparently did, submit by staying inside. Third, the state Supreme Court shied away from the rule we apply today for fear that it would encompass even those motorists following the vehicle subject to the traffic stop who, by virtue of the original detention, are forced to slow down and perhaps even come to a halt in order to accommodate that vehicle's submission to police authority, but an occupant of a car who knows that he is stuck in traffic because another car has been pulled over, like the motorist who can't even make out why the road is suddenly clogged, would not perceive a show of authority as directed at him or his car. Such incidental restrictions on freedom of movement would not tend to affect the individual's sense of security and privacy in traveling in an automobile. Indeed, the consequence to worry about would not flow from our conclusion, but from the rule that most all courts have rejected, holding that passenger in private car is not without more seized in a traffic stop would invite police officers to stop cars with passengers regardless of probable cause or reasonable suspicion that anything illegal. The fact that evidence uncovered as a result of an arbitrary traffic stop would still be admissible against any passenger would be a powerful incentive to run the kind of roving patrols that will still violate the driver's Fourth Amendment right.